stand as a people with one song, with one voice. We're a nation undivided and poised. We will take a stand and build our land in faith to defend what is ours.
Good afternoon, everyone. Hello. Good afternoon, everyone.
Hello, bro. Good afternoon.
Yes, thank you. Thank you. Just reaching out to say we'll be starting in the next couple of minutes. I just want to confirm that all our distinguished panelists are on board. Please bear with us. We'll be starting in exactly 5 minutes. Thank you. Thank you.
You're welcome.
Okay, welcome back, everybody. Thank you once again for joining us at this very important webinar being put together by the Federal Consumer Protection Competition and Consumer Protection Commission in collaboration with the Faculty of Law, University of Lagos. Today, we're going to be discussing a very important and very contemporary topic, which is abuse of market dominance and unfair labor practices. I'm sure you will all agree with me that this is one of the trending issues now in Nigeria. And this afternoon, we want to explore the various dimensions of this very important socio-economic and legal issue. And the organizers have assembled a team of experts who are well-versed in this topic to shed light on all the various dimensions and the critical aspects. So I welcome you all to this webinar. It's my pleasure to introduce both organizers of the webinar, the Federal Competition and Consumer Protection Commission. Thank you very much for putting this together. We also have the Faculty of Law, University of Lagos. You are very welcome, and thank you for joining us. I will now proceed to welcome our eminent speakers who will be discussing the critical dimensions of this very important topic. And the first speaker that I'm going to be introducing to us is none other than our own Mr. Femi Falana, Senior Advocate of Nigeria. Mr. Falana is a partner in the law firm of Falana and Falana, a leading law firm in Nigeria. He has distinguished himself in the fields of labor law, constitutional law, and human rights, among others. Please mute yourselves if you're not speaking. Please mute yourselves. Thank you. So Mr. Falana, as I said, is a leading expert in the fields of labor law, constitutional law, and human rights. And he is going to be one of the two lead speakers that would interrogate the issue of unfair labor practices and abuse of dominant position. Secondly, we have another eminent scholar, a professor of law and senior advocate at the Faculty of Law, University of Lagos. He is Professor Joseph Abugu. Professor Abugu is also a principal consultant in the law firm of Abugu & Co., a US Fulbright scholar, and he specializes in competition law, securities law, and industrial law. You are welcome, Mr. Femi Falano, SAN, and Professor Joseph Abugu, SAN. Both lead speakers will spend 20 minutes each speaking to the topic. So whilst one would lead the discussion on abuse of dominant position, the other would be shedding light on unfair labor practices. Beyond the two lead speakers, we're also going to have 4 discussants. They would further elaborate on the topic of the day. The 4 discussants will be introduced one after the other, after we have listened to the lead speakers. So I think we're ready to start now. Mr. Femi Falano, Senior Advocate of Nigeria, you have the floor. You have 20 minutes. Thank you. Please unmute yourself, sir. Hello.
He's about joining, Prof.
Oh, okay, okay. I thought I saw him here earlier. Maybe he dropped off. Okay, okay. In that case, I think we will then start with Professor Joseph Abugu. Professor Abugu is here with us already. Prof, you have 20 minutes.
All right, good afternoon, everyone. Moderator, Professor Adejoke Oyewumi, I thank you for this opportunity. And I also want to express my appreciation to the Federal Competition and Consumer Protection Commission, as well as the Faculty of Law, University of Lagos, that have put this event together. Market dominance is a competition issue, and unfair labor practice, again, clearly is a labor law issue. There is an intersection between these two, and that is what we intend to interrogate this afternoon. I have a couple of slides which I'm sharing now to all participants. I guess that will make communication and comprehension easier for all of us. And I'm sure at the end of the whole exercise, the slides will be shared to all participants. So I welcome you all to this presentation. Now, the relationship between competition law and labor law has traditionally been viewed as parallel rather than intersecting. While competition law addresses market structures and consumer welfare, labor law regulates employment relations and workers' welfare. In practice, however, the two domains do converge. The abuse of dominance in product markets will frequently, invariably translate into distortions in the labor market, where employees lacking bargaining power are compelled to endure unfair wages, precarious contracts, and limited mobility. The federal government in 2018 promulgated the Federal Competition and Statute. The Commission also made the Abuse of Dominance Regulations 2022. Under the Act, Dominance is not per se unlawful. It is the abuse of it that is prescribed, particularly where it results in exploitative or exclusionary practices. The Abuse of Dominance Regulation of 2022 clarify thresholds for dominance and provide examples of prohibited conduct. On the other hand, the Labour Act establishes the minimum standards for wages, contracts, instances of redundancy and working conditions. Although the FCCPA Act did not explicitly categorize workers as consumers of labor, a purposive interpretation of the FCCPA Act, when read with the Labour Act, supports the conclusion that workers can be protected within the broader consumer welfare paradigm. This paper, my presentation, is going to explore the intersection. Receive the call.
Yeah.
We'll explore the intersection between competition law and labor law in Nigeria, focusing on the implications of abuse of market dominance for workers' rights. We're going to demonstrate through statutory exigencies, comparative case law, and practical examples that abuse of dominance in labor markets leads to wage suppression, erosion of working conditions, and barriers to mobility, thereby undermining both competition and labor rights. And this is the point of convergence. Now, in Nigeria, the commercial landscape has traditionally been dotted with monopolies and enterprises that enjoy dominance in specific sectors. Section 16 subsection paragraph C of the 1999 Constitution underscored the right of the government to operate and manage major sectors of the economy. This has given fill-up to the emergence of statutory monopolies. We used to know them: NEPA, NITEL, Nigeria Airways, Nigeria National Shipping Line, and several others. It also formed the basis of the power of the government to grant pioneer status to strategic enterprises, which invariably operated as monopolies. Now, this has not fundamentally changed the wave of commercialization and privatization, that has taken place since 1977 till date. In Nigeria, the FCCPA Act provides substantive framework for regulating market dominance. Sections 70 to 74 of the Act establish the concept of dominance, defines what is abuse, and empowers the Federal Competition and Consumer Protection Commission to investigate and sanction such conduct. The Commission has brought investigative and remedial powers, as demonstrated in some of the matters that are already in the public domain, notably the investigation and the outcome of the tribunal proceedings in the case of FCCPC against Meta, and WhatsApp. Now, labor rights are implicated because abuse of dominance diminishes fair wages, free choice of employment, and collective bargaining, rights that are guaranteed under the Nigerian labor law, as well as international conventions to which Nigeria is a party. So, competition law enforcement thus serves as a complementary mechanism to uphold labor rights. The 2022 Abuse of Dominance Regulation supplements the Act by setting market share thresholds: 40% for single enterprise dominance, 25% in some cases for collective dominance, and provides illustrations of exploitative and exclusionary practices that the Act will not condone. On the other hand, Labor Act protects employees by prescribing conditions of employment, wages, redundancy procedures, and protections for women and young persons. While labor law is primarily designed to regulate employer-employee relations, the abuses that are prescribed under or prohibited under the FCCPA Act often directly impact these statutory labor rights, hence this convergence. So, what does the Act have to say about abuse of dominance? The FCCPA Act 2018 establishes a clear and structured framework for identifying dominance and prescribing its abuse. Section 70 defines what it is to be in a dominant position, which is to act to an appreciable extent independently of its competition, of competitors, customers, as well as consumers. Now, this definition under the Act mirrors international standards on this subject, notably Article 102 of the Treaty on the Functioning of the European Union, which focuses on independence from competitive restraints. The emphasis is on independence, and it reflects the harm associated with a breakdown in market discipline. It is noteworthy that Section 70 of the Act does not criminalize or stigmatize dominance itself. Being in a dominant position is not an offense, as certain firms will acquire dominance either through hard work, exploitation of synergies, and astute business practices. Now, what is abhorrent is when a firm capitalizes on a dominant position to engage in unscrupulous conduct which distorts efficiency in the market, or conduct which do not benefit the consumer. An offense of abuse of dominance will be established in such instances. And that is also not without the caveat that a firm may achieve a dominant position, but because of the innovation, which the firm introduces into that sector, and the pro-competitive benefits inherent in its conduct, it may be absorbed of an abuse of its dominant position. So the law therefore targets abuse, not mere size or success. The distinction therefore ensures that competition law remains an instrument for protecting welfare and not penalizing legitimate enterprises. Definition of dominance. A firm is considered dominant where it enjoys a position of economic strength, enabling it to prevent effective competition in the relevant market, and having the power to behave to an appreciable extent independently of its competitors and consumers. I have referred us to the case of R.J. Reynolds Tobacco Limited against Cigarette Shipper, of the Seventh Circuit of the Court of Appeal of the US, where the court stated that competition is a continuous and relentless strife for who will get the most supplies, which in most cases are in short supply. So the ultimate interest is the interest of the consumer. All right? A dominant position may be held by a single firm or a number of firms combined. I have referred to the abuse regulations, which prescribe a 40% threshold for a single firm to attain a position of dominance. And where there's a combination of firms, the percentage is 25. Now, prohibition. I have said abuse position is unlawful, but attaining a position of dominance itself is not unlawful. So the emphasis, therefore, is on those instances where that dominant position constitutes an abuse. Section 72, subsection 2 of the Act took some time in giving instances of situations that will constitute an abuse. The first of them in section 72, subparagraph A, is excessive pricing. Okay, charging an excessive price to the detriment of consumers. Okay, so this addresses exploitative practices where dominant firms exact rent disproportionate to cost or value. All right, so you are dominant, okay, but the law expects you in the pricing of your goods and services to be fair and reasonable. But when you then exact prices for services or goods that are disproportionate to the cost, input, or value under the Act, it will constitute, abuse of market dominance. Okay, and if you relate this to labor markets, this is where the payment of excessively depressed wages, where workers are unable to negotiate fair compensation due to employer dominance. In other words, in the labor market, where you have a dominant employer, because he dominantly controls the market, workers, employees do not have the free choice of mobility to move from that employment into another one. And that gives the employer the power to impose depressed wages. Rather than commensurate market wages, the employees suffer depressed wages. So just as consumers suffer when dominant firms impose excessive prices, workers also suffer due to the exercise of monopoly power. They suppress wages below competitive levels. The economic harm is analogous on both the consumer of goods services and in the case of employees who supply services to a dominant employer. So paragraph B of that same subsection mentioned exclusionary conditions. It prohibits imposing unfair trading conditions. So this encompasses contract terms that distort competition or unfairly disadvantage counterparties. In the employment context, this can manifest as unfair employment contracts, zero-hour arrangements, or rigid exclusivity clauses. So contracts of adhesion, common in consumer markets, have their labor counterpart in take-it-or-leave-it employment agreement, especially with non-negotiable clauses on working hours, leave, and termination. Paragraph C deals with right to deal. It prescribes where an enterprise refuses to give a competitor access to an essential facility. The essential facilities doctrine ensures that indispensable infrastructures or inputs are not withheld to foreclose competition. Transpose this to the labor market, essential facilities could be training, certification systems, professional networking that workers require to compete fairly. Where there is a dominant employer, now the dominant employer is able to water down, the rights to training, the certification system, the professional networking that workers will require. So on both sides, a refusal to deal in the consumer side has negative consequences. A dominant employer too, because of his dominancy, is also able to constrain rights that are enjoyed by employees. So denying access to essential services, is equated with refusing workers access to necessary tools that they require for their growth and promotion. So labor markets experience functional equivalence of tying and dyeing through non-compete clauses, mandatory exclusivity, or no-poach arrangements between firms, all of which restrain workers' mobility. Then there's tying and dyeing in paragraph G. It prohibits customers or suppliers, dealing exclusively among themselves or to avoid rivals. They enter into cartel arrangements. In labor markets, the equivalent is non-compete clauses or no-poach agreements between employers. They mirror this kind of restriction by limiting the workers' freedom to change employment. Now, by highlighting these parallels, the FCCPA Act and its regulations may, through positive, purposeful interpretation, be extended to provide indirect protection to workers as consumers of labor. Now, a little bit about what this abuse of regulation says. The abuse of dominance regulations operationalize the provisions of section 70 to 74 of the FCCPA. It provides clarity on thresholds, indicators, and enforcement tools. This ensures predictability for businesses and consistency in enforcement. Regulation 3, for instance, is one I've referred to, which prescribes a single firm dominance at 40% or more, and then collective dominance at 25% or more. Now, this quantitative threshold provides, an evidentiary presumption that reduces enforcement burdens Importantly, it aligns with international practice, where dominance, for example, in the EU is 40 to 50%, and in the US, it is 70%. With that, you see that the Nigerian threshold is lower now, but this is a reflection of the fragile and concentrated nature of local markets here in Nigeria. Regulation 5 and 6 identify abuses and distinguishes them from exploitative abuses, that cause direct harm to counterparties, and exclusionary abuses which forecloses rivals, reducing competition. All right. Exploitative abuses will include predatory pricing, excessive pricing, discriminatory treatment, and unfair trading terms. These are directly relevant to labor relations, where dominant employers impose one-sided contracts, suppress wages, and discriminate between categories of workers. The same thing with Regulation 5 on exclusionary abuses. This includes refusal to supply, margin squeeze, tying and bundling. In labor market, the equivalent will be exclusionary practices that are mirrored by anti-competitive hiring restrictions, poaching bans, requirement that workers deal exclusively with one employer, yellow dog contracts. Now, the regulations also provide for market definition methodologies, using tools such as, SNP, that ensures that dominance is assessed with properly delineated markets. This is critical in labor context, where the relevant market may be geographic, locality, specific, employment, or product-based with respect to specialized skills. Now, the nexus, as I've tried to create in all of this, is that while competition traditionally focuses on the supply side, dominance has great implications on the demand side of labor markets. A dominant firm will exercise monopoly power, where it becomes the principal or sole buyer of labor in a given market. And so such an undertaking is able to dictate wages, unilaterally setting them below competitive levels. Workers, in effect, then consume the labor market by offering their services, but receive diminished value. Okay, so
thank you so much. Thank you so much, Prof. You have just 2 minutes to wrap up. You still have another bite at the cherry, but please wrap up in a minute or two.
So thank you very much, moderator. So you see these in instances in cement production, how it affects skilled engineers, geologists, factory technicians, and so on and so forth. In the United States, I've given an example of the well-documented no-poach agreement between Apple, Google, and other Silicon Valley firms, which artificially restrain employees' mobility. Okay, and then, of course, extraordinary practices, as I've said, are related to job insecurity. And the impact on labor is twofold: reduced employment opportunities, redundancy pressures. So all of these are also connected. The same thing with gender and maternity rights, which the Labor Act exclusively protects under Section 54. A dominant employer is in a position to not adhere or partially adhere to some of these rights because there is no competition. All right. Now, on freedom of association and collective bargaining, I guess we'll come back to that when we treat the next paper on the issue of employee rights. I've given a few practical illustrations and comparative analysis from other jurisdictions. Suffice it at this point to conclude that abuse of market dominance and the protection of labor rights are deeply interconnected. The FCCPA Act, complemented by the abuse of dominance regulations, proscribes exploitative and exclusionary practices by dominant firms, and the Labor Act on its part sets out minimum standards of workers' protection, while the FCCPA does not classify workers as consumers of labor. Purposeful interpretation of its objectives and provisions, as I have just explained in the nexus between them, will require us to conclude that labor rights are protected in the same manner that consumer rights are protected under the FCCPA Act. Workers, like consumers, they participate in the same market. Where there is imbalance of power, it exposes them to exploitation. Treating workers as consumers of labor ensures that they act achieves its purpose of promoting welfare and protection Thank you very much, Mrs. Professor Moderator. This is my presentation at this point. Thank you very much.
Thank you very much. Thank you very much, Professor Abugu. Thank you for shedding light on this emerging area, because in Nigeria, it's an emerging area. As Prof has just elucidated, the governing statute was actually promulgated in 2018. Although before then we had the Consumer Protection Council Act, but a robust legislation dealing with both competition and consumer protection is a relatively new development. And we have this act now backed up by the abuse of dominance regulations of 2022. And Prof has made it very clear, and I think that's a major takeaway from there, that dominance in and of itself is not necessarily tantamount to abuse. It crosses the line to abuse when that position is utilized in an oppressive way or for exploitative purposes. And this is where, you know, labor law also becomes relevant, because abuse of dominant position, although often explored in the context of the fixing of monopoly prices or excessively high prices, but also in the context of labor, it can mean payment of exploitative wages as well as poor conditions of employment, where employees, you know, feel stuck, where they do not have the liberty to exit and go to other places because their employer happens to occupy a dominant position. We often talk about freedom of contract in employment, freedom of contract, sanctity of contract. But we all know that sometimes this may actually be fictitious. The freedom may be fictitious if you don't have many options. So that's where this issue of dominance comes in. Thank you very much once again, Professor Abugu. It's my pleasure now to move on to the second speaker, the second lead speaker, Mr. Femi Falana, Senior Advocate of Nigeria, is one of the leading practitioners in the area of labor and employment law, as well as constitutional law and human rights. And he would also be sharing with us his own thoughts on this very important area. I assume he will talk more about the labor dimension, but of course the learned Silk is free to share his views, you know, freely, as long as it falls within the scope of today's discourse. We would also like to hear from you whether there's an emerging jurisprudence in Nigeria in this area. We see that the issue of competition law and protection of competition is very well established, well entrenched in Europe. In the US, it's antitrust. In Europe, competition law, we have adopted the nomenclature of Europe. But when it comes to actual, you know, cases involving jurisdiction,
Any means at all.
hello?
Yeah, I'm here now. Can you hear me,
Okay.
madam?
Yes, yes.
Yeah, Prof, thank you very much. I think very briefly, as we're all aware, very recently, the National Union of Petroleum and Gas Workers, that is NUPEN, directed all its members to embark on a strike with effect from Monday, September 9. The strike was a protest against the plan of the Dangote Petroleum Refinery to force newly recruited drivers to sign an undertaking not to belong to any existing union in the oil and gas industry in the country. The policy of the Dangote Group clearly violates Section 40 of the Constitution, which guarantees freedom of association, Section 9(6) of the Trade Union Act, as well as Article 10 of the African Charter on Human and People's Rights. Furthermore, the policy also constitutes a breach of the provisions of the Freedom of Association and Protection of the Right to Organize Convention 1948, number 87, and the Right to Organize and Collective Bargaining Convention 1949, number 98 of the International Labour Organization, as well as the United Nations Universal Declaration of Human Rights, the International Covenant on Economic, Social, and Cultural Rights, as well as the International Covenant on Civil and Political Rights, which have been ratified by Nigeria and which are enforceable in the National Industrial Code. In view of the legal obligation imposed on the federal government by the Constitution, the Trade Union Act, and the international instrument, labor instrument, to respect the fundamental right of workers to freedom of association, the right of trade unions to organize them. The Register of Trade Unions ought to have called the Dangote Petroleum Refinery Group to order without even a strike. The federal, as just Prof. Bugo has just made clear, the Federal Competition and Consumer Protection Commission, for me, should halt the monopolistic practices of the Dangote Group forthwith as they violate the Federal Competition and Consumer Protection Act of 2018. Even though powerful trade unions exist in all capitalist countries, including the United Kingdom and the United States of America, the Dangote Group is apparently determined to obliterate trade unions in Nigeria because it has been allowed to operate outside the ambit of the law in other areas. However, the Dangote Group ought to be reminded that the struggle of Nigerian workers to unionize was fought and won under the British colonial regime. To that extent, no employer under the current labor law regime in Nigeria can ban trade unions or prevent trade unions from organizing. And happily, the federal government stood its ground in the reconciliation meeting held between the Dangote Group and the NUPENG, when the government made the point, and this emerged in the agreement signed by both parties, that under the existing labor laws in Nigeria, unionization is a right of workers, while acknowledging that under the Trade Union Amendment Act of 2005, workers have the right to opt out of unions, but no employer is empowered by law to ban trade unions or prevent workers from belonging to trade unions. As far as the struggle of Nigerian workers can be said to be concerned, and happily the NLC and Pengasin clear solidarity with the striking NUPENG in ensuring that the battle was won. It is hoped that other employers of, because if Dangote Group had won, that might have brought an end to trade unions in Nigeria. So all aware, under the colonial regime, unionization was a criminal offense. But as I said, Nigerian workers fought against such slavish policy and won the battle to unionize. Nupeng and Pengassin existed in the NAPC when it was the sole refiner of crude oil in Nigeria. And I wish to say that now there are trade unions in Shell and other oil and gas companies operating in Nigeria. There are trade unions in the modular refineries in the country. It may interest this distinguished audience of intellectuals that in July this year, Nigeria's daily gas production rose to 7.59 billion standard cubic feet per day. Yet the LNG has not asked the workers not to sign, it's not asked workers to sign an illegal agreement not to belong to trade unions. And I therefore submit that the battle by Dangote is a lost one as far as the law is concerned. So if Dangote and is in Dangote Group and other employers of labor want to prevent workers from belonging to trade union, they definitely would have to go to the National Assembly and get the law amended, particularly the Trade Union Act as well as the Constitution, by saying that they can operate without unions in Nigeria. But as has been made clear, under the Trade Union Act, under the Constitution, and there have been several cases in the National Industrial Court and in the regular courts where the right of workers to belong to trade unions of their choice have been recognized. Therefore, I wish to submit that the strike that has just been called off will have been unnecessary if the Dangote Group had recognized the constitutional right as well as the statutory right of workers to belong to trade unions of their choice. Apart from the Federal Consumer Protection Act, we also still have the Price Control Act operating in the country. And in the case of Femi Falana, Attorney General of the Federation, the Federal High Court made the point that petroleum products under that law, I think the Price Control Act, are essential commodities. And as far as that law is concerned, the government has a duty, in spite of the provisions of the PIA, which has can be said to have deregulated, the petroleum industry. The federal government still has the duty to ensure that Nigerian people are not exploited. So that is why petroleum products are essential control commodities, and therefore the government has a duty to ensure that Nigerians are not subjected to uncontrolled exploitation. And as I did say on Channels Television publicly yesterday, it was reported, I think by Punch yesterday, that a liter of petroleum is now cheaper in Togo than Nigeria. In other words, oil supplied to Togo by Dangote, it's 65 naira cheaper than the current price in Nigeria. And we have also called on the Nigerian Labour Congress to intervene and ensure that Nigerians are not overexploited. I was made to realize this morning that it's a war, a trade war going on between other importers of petroleum products, of fuel, and the Dangote Group. But Nigerians should not be made to suffer, As we are all aware, prices are imposed without any control. We wake up every morning and be told that, the Dangote Group on NNPC have fixed new prices for petroleum products. And I do hope that now that Nupeng and Pengassin have challenged the monopolistic control of the petroleum industry by the Dangote Group. I do hope that together with NLC, we can have some measure of control and regulation. The government will have to be compelled to intervene more decisively and not leave Nigerians to market forces, as it is the case today. And thank you very much for this opportunity.
Thank you very much, Mr. Femi Falana, SAN. Thank you for shedding light on the contemporary dimensions of this discourse now, and particularly for reiterating the point that we have certain rights that are guaranteed to labor under the Constitution, under extant statutes, particularly the Trade Unions Act, and also relevant international conventions, particularly the ILO conventions number 87 and 98. Incidentally, out of the 189 ILO conventions, only eight are deemed to be fundamental conventions, and 2 of the 8 protect or safeguard the rights to freedom of association and collective bargaining. And so this shows, this shows the importance that is attached to this freedom, both at the national and the international level. Thank you very much.
Thank you.
Now we are going to go into the discussion session. We're going to be interacting with some of our eminent colleagues who have been invited to share their thoughts also in 10-minute interventions. So we will start. Let me just quickly introduce our discussants, and then we'll take them one after the other in 10-minute interventions before we open up the floor for further interventions by our distinguished audience. So I have with me here Mr. Afolabi Kuti. Mr. Afolabi Kuti, Senior Advocate of Nigeria, is the lead partner of Union Attorneys. Union Attorneys incorporates Kuti Legal. He is an expert in disputes resolution and employment law practice. And his firm is also into corporate and commercial law. And he has several decades experience in this area. So he is going to be making his intervention also on this very important area. Similarly, we have one of, she's my colleague here at the University of Lagos, an associate professor at the Faculty of Management Sciences. She's a Fulbright scholar and has a multidisciplinary background which spans law, sociology, and industrial relations. I'm talking about Dr. Rosemary Danesi. Thank you. Then we have also the managing partner of Hybrid Solicitors, who has also made his mark as the managing editor of the Nigerian Labor Law Review. That is Mr. Bimbo Atilola. Mr. Atilola, of course, specializes in labor law, taxation, and commercial law. And he has consulted for the federal government, the Chartered Institute of Personnel Management, among others. Last but certainly not the least, we have Mr. Kendi Bamiwola. Mr. Bamiwola similarly holds dual degrees in economics and law. He's an author, an academic, and a practitioner. And presently he chairs the Continuing Legal Education Committee of the Nigerian Bar Association, Ilaro branch. You are welcome, dear colleagues. It's also my pleasure and great pride to say that they are all alumni of the Faculty of Law, University of Lagos. Thank you for joining us and welcome. I will be starting this discussion with Dr. Danesi, Dr. Rosemary Danesi. And for her part, she's going to look more closely. Mr. Falana has shared his thoughts on the fundamental right to freedom of association and collective bargaining and the import of this. I want Dr. Danesi to further elucidate on this. Freedom of association, the right to join a labor union. What does this entail? Because sometimes when we talk about freedom of association, the right to join, does it also go the other way, or how do you view this? Dr. Danesi, please don't use more than 10 minutes. You have a maximum of 10 minutes because we also want the audience to be able to participate. Please unmute yourself and let's have your intervention. Thank you. Dr. Danesi? Okay. Okay, so while we wait for Dr. Danesi, I think she's having network issues. While we wait for Dr. Danesi, let me call on Mr. Bimbo Atilola to get the discussion going. Mr. Atilola, please, you have the floor. Please unmute yourself. Please unmute yourself.
Thank you very much, distinguished moderator. I will quickly stand on all the existing protocols. So our distinguished speakers have spoken extensively on the dominance on workers' rights. And of course, distinguished Mr. Falana has spoken extensively on freedom of association and workers' rights. So I don't think I need to further emphasize on that, other than to say that market dominance even go beyond the freedom of association. It leads to wage erosion in the sense that it makes the labor market less competitive because mobility of labor is reduced. If you dominate the market, there are less employers to work to. So you can dominate the industry, also dictate salaries and wages indiscriminately. In fact, economists, they call this monopsony, where employers dominate the labor market through wages and salaries manipulation. Of course, we also have the use of non-compete clauses. And like Professor Abubu says, employer can even come together and say, look, we are not going to poach one another staff. All these have adverse implications on workers' mobility. Now, having said this, people always think abuse of market dominance is only on the part of employers of labor. Workers and trade unions too also do abuse market dominance, especially in the context of essential services industry. For instance, let's look at the example that the distinguished SAL talked about, Mr. Femi Falana, the current problem or disagreement between Dangote and Nupeng. So, as we all know, oil and gas, especially the petroleum product distribution industry, comes under the Essential Services Act because of the essential nature of the non-substitute nature of the product that they distribute. So in the wisdom of the lawmakers, they felt that, look, that industry should have special labor regulation because they constitute essential services. But what do we see in Nigeria? We also see a situation where NUPENG and Pegasan also abuse their dominance in an essential services industry with adverse implications, not only for Nigerians, not only for employers, but also for the economy. Why is it that whenever NUPENG or Pegasan, when they sneeze, it's not only their employers that catches cold, federal government too will catch cold, Nigerians who will face the challenge of fuel scarcity will also catch cold. And in few days, federal government will invite them to collective bargaining table, to meetings. Let's resolve this issue very quickly. It is not the same with ASU. If ASU issues strike warning, federal government may not talk to them in months because there are substitutes. We have private universities and they are increasing in numbers, offering all the relevant courses, including law, including medicine. So they are becoming less dominant. Their ability to abuse their union right is less potent because they no longer enjoy monopoly. But when NUPENG and Pegasan, when a mere threat of strike will send the federal government G3 and everybody will be calling them for meeting. So the unfair labor practices is not only on the part of employers, although it is more on the part of employers, but jurisprudence of unfair labor practices also extend to capacity of employees and trade unions to abuse their dominant positions. Now, Nigerian trade unions, with all due respect and with all reference to them, we are all aware that there are mandatory statutory provisions for declaring strikes and picketing under the Nigerian law. These provisions are contained in the Trade Disputes Act, section 3, 4, 5, 6 to 10. You must have explored collective bargaining, you must have explored mediation, conciliation by the Minister of Labor or any of his appointed mediators or conciliators. Then you go to industrial arbitration panel. But the question is this: how many times do NUPENG and Pegasan, how many times do they explore these mandatory dispute resolution procedures before you embark on strike? What we see most times is just to issue a 14 days ultimatum and they threaten to embark on strike without completing the mandatory procedures prescribed under the Trade Dispute Act, including the relevant provisions under the Trade Dispute Essential Services Act. And when you embark on those strikes in contravention of the law, they are also illegal strike. So a threat of illegal strike in essential services industry is also an abuse of workers and trade unions' dominant position in an essential services industry. So it is important that we balance it. So what is the way forward? In my view, the rules are very clear. Both parties only just need to comply with the rules. One, Section 40 and the ILO Constitution guarantees the freedom of association. Like Mr. Falana explained, that right is a constitutional right. No employer has the right to take that right away. But again, we must also understand and emphasize to the trade unions community that they should be reminded that membership of a trade union is voluntary. It is on voluntary basis. No union has the right to compel another, to compel an employee to join a union. But what we see in practice is that whenever a union embarks on a strike action, what they do is that they close the offices of all the staff, Some of them even chase management staff and senior management staff. They chase them away. They barricade the hall. That is an infraction of other people's rights who may not be members of your union and who may not even have subscribed to your objectives. Picketing is a form of industrial action recognized under the Trade Dispute Act in Nigeria. But what we practice in Nigeria by our trade unions is not picketing. What the law says, what Trade Dispute Act says about picketing is that you should go to the premises of the employer and persuade by carrying placards. Carry placards. And the law goes further to state that you should not block entrance to premises. You should not disturb free entry and exit of workers or visitors of anybody that wants to enter the premises. But is that what we do in Nigeria when we picket? The answer is no. Workers too and their unions also abuse their dominant positions. Many times you see them burning tires on the road, block the road in the name of picketing. That is not picketing. Picketing is persuasion. So industrial actions has been significantly abused in Nigeria. And like I said, this is common in essential services industry, especially in the industry where it is difficult to have substitutes. Like I said, ASU can issue threat of strike from today till next year because they do not occupy dominant positions in the educational market, in the educational industry. We have private universities. They may not listen to them. So, other thing that we must emphasize is that, and I think employers of labor should begin to also think about this. Trade union membership, like I said, is voluntary. But my experience in this industry has shown that
yes, you should be wrapping up, Mr. Lola, please.
Okay, I will round up.
You should be wrapping up.
My personal experience in this industry has shown that most times it is not the unions that run to meet workers in their respective industries or companies that want to come and organize you. More often than not, it is vice versa. Most times, it is workers who feel that they are being unfairly dealt with, who perceive unfair labor practices or exploitation, that usually run to meet trade unions and say, please, come and rescue us. So whenever a trade union comes to an organization to organize, 90% it is the workers that have invited them. And that tells you that employers too should need to look inward to reduce the tension that this may cause in industrial relations. So finally, the right of workers to join a trade union is a constitutional right recognized by the ILO Convention. No employer should trample upon it. Similarly, employers are owners of capital. They also have the right to organize their business in a way that makes them to be competitive. But this does not include frustrating union rights. Thank you very much. So, Prof, I'm through. Thank you.
Yes, thank you very much, Mr. Atilola, for your intervention. Thank you particularly for also looking at this from the other perspective, because if we look at the third alteration to the Constitution of Nigeria, Section 254C, that talks about the jurisdiction of the National Industrial Court, there we have specific reference to unfair labor practices. And if we look at the developments, the jurisprudence that has emerged from the courts in respect of this particular provision, we'll find, as you have rightly said, that unfair labor practices comprise both employers' unfair labor practices as well as employees' unfair labor practices. I don't know whether I should descend into the arena to become a panelist and respond to your pointed references to my own union, which is ASU, or whether
Please go ahead, Prof.
Professionalism.
As the lawyer to us, I will respond to
you hold the yam, Prof, you hold the yam and the knife. Please enter into the other. You hold the knife and the yam.
Not be sent into their government.
Well, I don't want my dean to query me, so don't let me descend into the arena. Let me just do what
Prof, don't descend. I'm still going to reply as the lawyer to ASU.
Thank you, Learned Silk. Thank you very much. Yes. So
my very senior Mr. Falana, you have a right of point of law, reply point of law.
Right of point of law, yes, please.
Very well, sir.
Yes. Okay. So thank you very much. You have in your intervention tried to balance the competing interests between employers, employees, and very importantly, public interests, which is the consumer protection or public interest, as I said, dimension of this. So thank you for that intervention. The next speaker that we're going to have is Dr. Rosemary Danesi. Dr. Danesi is going to look a little bit more closely at this principle of voluntarism. We say there's freedom of association and the right to collective bargaining. In this context, what do we mean? How should we interpret this? Because when, as Mr. Atilola said, some want to carry on with their work and others come to chase them out, with sticks and all that. I mean, how do we explain this in the light of the legal provisions on freedom, the operative word there now being freedom of association or voluntarism? Dr. Mrs. Danesi, please bring your multidisciplinary background to bear in this. We know you are not only a lawyer, you also have backgrounds in sociology, how society interacts, as well as industrial relations. So how should we interpret, how has this played out in Nigeria? And maybe you also want to do a bit of a comparative thing. I don't know what your intervention is, but you do have the floor. Please, your intervention should be a maximum of 10 minutes. Thank you, Dr. Danesi.
Thank you very much, Prof. Good afternoon, everyone, my learned seniors and colleagues and our audience. Yes, when we talk about freedom of association, we also have to also note that freedom of association, if as a worker, according to this Section 40 of the Constitution of the Federal Republic of Nigeria as amended, it says that everyone has a right to belong to a trade union or to form a trade union. So inherently, that means that you also have a right not to belong to a trade union. And we have a case to that effect. We have the case of Egba and Adefarasin in 1985. The court stressed that freedom of association includes the right not to associate. But the way we look at it in Nigeria, we believe that once you are in the union, you must once you are a worker, you must belong to a trade union that is already in existence. You may decide that you don't want to be in that trade union. Now, also, we're talking about dominance. There's also dominance when you talk about trade unionism in Nigeria. And people tend to forget that there was an amendment to the Trade Unions Act to the Trade Unions Act in 2005 under the regime of President Obasanjo, which says that it encourages voluntarism. You don't have to belong to ASU if you don't want to. It just happens that ASU is the only union, for instance, in the education, public education system in Nigeria. And then you have NUPENG and PENGAS in the oil and gas industry. A lot of times you find NUPENG coming out to say that anybody who works in that industry must be a member of NUPENG. It doesn't go that way. I think some of our union members need some kind of schooling in that regard. That amendment has long. In a trade union is not compulsory. It is a voluntary thing. It is not compulsory, and that's also. You don't have to, there doesn't have to be just one union in a particular sector. You can have more than one union in a particular sector. But in practice, we don't see that happening. We see that in every sector, we have only one union. And anybody who is in that section must be a member of that union. For instance, the Dangote situation, where NUPENG insists that the people work in the Dangote refinery have to be in their union. I mean, if the people in the Dangote refinery decide to form another union, it's fine, as long as the registrar of trade union registers them, as long as they comply with the conditions for registration, they can register and become a union, and then automatically the employer will recognize them as soon as they are the registrar of trade union registers them. So there's no compulsion in joining or forming a trade union, and you can see that in the ILO Convention 87. It is, in fact, you don't, under the convention, you don't even need prior authorization by government or any authority whatsoever. That is where the freedom really applies. You don't need anybody to authorize that you must join a particular trade union or you must form a particular trade union. But what we have today is dominance by NLC, by TUC, by NUPENG, by ASU, and some other unions, as it were. Let me give you an example. When I was doing my PhD in England, it was then I discovered that in the university system, they had about 3 unions. And then they gave notice and said, lecturers who are not in that particular union will go on and teach. And I was surprised because I was coming from a system where there was dominance, by a particular trade union. So ILO has made it clear that it is a voluntary thing. You don't have to coerce people to join your union. I mean, they have a right to form or belong to a different union. But as it were, like Bimbo said earlier on, when NUPENG coughs, everybody catches a cold because of the nature of that industry. But that is not to say that everybody that works in that industry must belong to NUPENG or Pengasan. They have a right to form their own union. But then political consideration will come in because of the nature of that particular sector, because that's where we get oil revenue from. So we need to understand that, we need to understand that every worker has a right to join or belong to any or form a trade union of their choice, as long as the registrar of trade union recognizes the union and and they are registered. So, though, what is going on in that industry now? There's a lot of political maneuvering here and there, but I'm just stating what the law says about it. Bimbo had earlier talked about going through the whole hog before you can even call out your members for strike. You have to look at Section 18 of the Trade Dispute Act, which says you must go through mediation, conciliation, arbitration, and a national industrial court before you can even consider going on strike. And then the essential services thing also applies in that area. But as it were, you see that a lot of times that route is not usually taken. They just issue a warning, oh, we are giving you 1 week ultimatum or 2 weeks ultimatum, and then we will, if you don't do what we want you to do, then we'll call out our members on strike. That does not augur well for industrial harmony and even industrial democracy. We must understand that unionism is not something that we have to do by being coerced into joining a particular trade union. It is something that is voluntary, especially with the amendment of the Trade Union Act of 2005. So that is the way I think the law puts it. We must ensure that we go according to what the law says. There's freedom of association, and then there's also freedom not to associate. I don't think in this times, considering the way the world of work is now, that any union should have monopoly as we are having now in that particular industry, which has resulted in dominance. Any association that comes up or workers that come up and say, we don't want to join your union, we will want to form our own union, they are met with resistance and stiff opposition. I don't think we should, at this point, be canvassing that attitude is the best attitude. For me, it is against international law and it is against international best practices. It's also against the Nigerian constitution as well as the trade union law. Because what they are operating as it is now is what you call a closed shop system, whereby for you to be in that industry, you have to be in those particular unions. And our constitution, as well as the Labor Act, does not allow for closed shop system under Section 9, subsection 6 of the Labor Act. So we have to look deeply into that. Then my learned senior son, Mr. Femi Falano, I know he's going to talk about that. We may not share the same views on that, but I believe strongly that when we talk about industrial democracy and industrial harmony, we should talk about ensuring that there's voluntarism and there's freedom to associate and freedom not to associate. The rest for me is just political, So, and I believe that is unfair labor practice when you operate a closed shop system, and then you don't want other people to form other unions other than your own. Thank you very much.
Thank you very much, Dr. Danesi. Thank you. So again, we have her perspective on voluntarism and freedom to associate. The operative word there being freedom, as I said earlier. So she has shed light on that. There should be no compulsion. Trade unions for very many years, only one trade union could exist or be recognized in particular sectors or unions, or sorry, in particular sectors. And so some unions actually became extremely powerful, extremely dominant, and they think they're operating as if it's still business as usual. However, with the departure from that very strict position, the real operation of freedom can now be brought to bear. So we have that legally, but do we have it in practice? That
yes,
appears.
Yes, we have it in practice.
Yes,
we have three unions in the university. Three.
Yes. You still have another bite at the cherry, Lanet Silk. Let me just quickly go now to Mr. Kende Bamiwola. Mr. Bamiwola will shed light on, or will share his own views about the discussion that is on the table. I don't know whether he wants to look more at the competition law side of it, or the unfair labor practices aspect. Please, you have the freedom to make your intervention. Do not exceed 10 minutes. Thank you, Mr. Bamiwola.
Okay.
Please unmute yourself.
Thank you very much. Thank you very much. I hope you can hear me.
Yes, we can.
Okay, let me first of all thank the Federal Competition and Consumer Protection Commission and my alma mater, University of Lagos, for giving me this opportunity to make my contribution. I want to thank my learned seniors, those who have spoken. Though I want to disagree with some of the view, especially that of Mr. Bimbo, Atilola, and Associate Professor Danise. Well, it was my teacher of jurisprudence, Professor Akin Oyebode, who said 2 lawyers, 3 opinions. My opinion may differ. However, I won't allow different opinions to take much of the time because I have things that say about the competition and employees' rights generally, as far as trade unionism is concerned. The first question that I is this, and no, Mr. Taylor does not have a right of reply again. How do we balance the inequality in bargaining power? If by your submission that the procedures laid down in Section 3, Section 5, Section 8, and Section 13 of the Trade Dispute Act should be followed, we must pay attention to Section 17 of the same law that says even after mediation, after conciliation and arbitration, you go to National Industrial Court. After the award of the National Industrial Court, anybody who is displeased with that award will be prevented from going to strike, but that displeasure will be seen as a new dispute. The question is, when are we going to have legal strike in Nigeria? Don't forget that the first Trade Union Act of 1871 in the UK, United Kingdom, was a product of strike and agitation. Of course, when they started making their demands, we remember what happened with the Statute of Conspirators, 1292 and 1308, which was followed by the Statute of Labour. I'm not going to go to those details. Then again, I want to quickly respond to Professor Danise's view about some trade union monopoly of, let me use, by virtue of the topic we are discussing, dominance. We should not forget that the law under Trade Union Act, especially the Trade Union Amendment Act 2005, says if there is an existing trade union in that sector, the register of trade union will refuse registration of the trade union. Having said that, let me now come to my point on competition. Our problem in this part of the world, Nigeria, is a structural problem. What type of market system are we operating? Can we call ours a capitalist system? No. Is it a system, oligopoly? Can we call it a monopoly? No. We should not forget that there is a strong relationship between structure, conduct, and performance. Three things. The structure of the market. When you have a particular firm or few firms called oligopoly who have dominance over the economic production and supply, of course, the labor. What am I trying to say here? It is the type of market structure that has allowed some of these things. What of the conduct of employer and employee? I will now come to the salient point of employees' right. Most importantly, on the right to join any trade union of choice. A lot has been said about that. But where I want to hammer much is the issue of strike. Now, it is agreed, a lot of scholars and writers, they have emphasized the point that there is disparity or disequilibrium in the bargaining power between employee and employers. And don't forget that the goal of every business organization is profit maximization. And the theme or the concept of corporate governance is saying those who have helped in making the profit for the organization, they should be allowed to eat out of their sweat. Right from the days of the lords and farsals or serfs, there has been a struggle. And how do we resolve this struggle? And that is where the issue of regulation by government, who's supposed to be neutral, who's supposed not to be in business. But if you look at Nigerian situation now, it appears that the government is even the highest employer of labor. And just like from the popular Yoruba adage, there is no one that will give a hole to make a ridge or to clear the way that will not do it onto his side. And that is what we are witnessing. The brief or that are we aware that it is long overdue? It's even calling for reform. We said this trade union act and it's criminalized some of the that consider as labor rights. Right from the days of London and right to strike has been there. Don't forget our constitution that section 39 guarantees freedom of expression. Section 40 guarantees freedom of association. I see nothing bad in after dialoguing, after making your points that you want to share part of the profit of the organization and the employer of labor. They are not doing the needful by seeing to the welfare of the employee. Now the employee now, in order now to press on their demand, they are now saying they strike. I agree perfectly with the example given about ASU or people when they go on strike. We shouldn't forget the fact that, yes, I will agree that any strike embarked upon by the workers or people who belong to the essential services will be illegal. But essential services, people cleaning road, cleaning the road and doing other things are considered essential services. I think it's a way. We don't call an issue attack, which is necessary. To me, the law is non-negotiable. That no one can force the of any trade union. It is anybody who is not before to on your part, those who don't.
Oh, your network is so poor. Mr. Bamiwala, I hope your video is not. Yes.
Oh,
maybe you should try and move your position a bit, even though you should be wrapping up now. But please try and move your position so that we can hear you better.
Okay, can you hear you better now?
Well, yes, it's better. Hello. Oh.
For the two of us, Convention 1 of the ILO Convention, and I think by now, from the 2020 Convention, 191 and 206 regulations, Nigeria is not a nation, international, all rights that have been released, whether it's discrimination, whether it's from or going any of their choice, Convention 100, all choices are sacrosanct. To me, trade dispute act is
we can't we are not really following you anymore because the network is poor. But if you have an alternative, maybe I can give you a couple of minutes later on. But yes, I think you should just wrap up. Yes.
Okay, thank you very much. In summary, rights of employees generally, especially trade union members, should be respected. And the procedure contained in the Trade Dispute Act, they are too cumbersome, and employment has to do with sustainability. And rights that are considered as employees' rights, they have nexus with fundamental rights. So finally, employees' rights are fundamental rights. If you check all of them, whether discrimination, association, they are contained in Chapter 2. So thank you very much. Thank you very much. If I have the time, I will appreciate on that again. Thank you very much.
Thank you very much, Mr. Kende Bamiwala. Thank you for your kind intervention. You have also contributed significantly to the discourse by shedding light on the dimensions of trade unionism, the legal framework, as well as the practice of the rights in the different sectors. Thank you very much. To wrap up the discussion session, we're now going to invite none other than Mr. Afolabi Kuti, Senior Advocate of Nigeria. Mr. Kuti, I am not going to restrict you to any particular sector. You have listened to both lead speakers, and I'm sure you have been able to decide in which areas you feel you want to make interventions. But please do bear in mind that the ultimate purpose of this webinar is not just for us to talk about the problems, the issues, and the challenges, but also these should be targeted at law reform. In what areas should we be thinking about law reform? Are the laws adequate? Is it with regard to their, to their implementation that we have issues, or the law itself is in need of reform? So please make your interventions. Do not exceed 10 minutes. You can talk about
thank you.
Anything that is on the table, but also please think about law reform. And please, our distinguished audience, if you have questions or contributions, can you start dropping this in the chat box so that the speakers can address it in due course? Thank you very much.
Thank you very much, the learned Prof. And I
well, I hope I'm not too big to break the table. So I'll just, I'll lean on the protocol already well established by the very esteemed speakers who have spoken before now. And thank you for affording me the opportunity to probably just look at a narrow prism of the whole discussion, which is, which ordinarily is what I'm actually tempted to look at, having listened to the various interventions. Unfortunately, didn't have an opportunity to have any paper before now. So, but what I did was I was writing as I listened keenly to the characteristic erudition of the lead speakers, Professor Abugu, SAN, and Egon Fadlan, SAN, and the no less distinguished discussant so far, others discussant. So my intervention will probably be situated around what didn't have a paper, but I was thinking as I listened that maybe what we should be discussing also should be looking at is context. And I think context would help to situate everything. And I draw my bearing from what this is about, abuse of market dominance and unfair labor practices. I listened to Professor Abugu. Prof, I mean, you have a further right of reply, but I struggle to really see how competition law can or is as it is as at present and is really engendering labor rights or is making provision for labor rights and better than what we have, not the Labor Act, but maybe the kind of intervention of the third alteration that allowed the industrial court to bring in what obtained in other climes, I mean, developed climes to factual situation before the court. And I also say this because in looking at the establishment statute that brought the FCCPC about, it's more of prohibiting restrictive or unfair business practices. I mean, if we're to relate that to the discussion so far, in my view, and then I'm subject to correction, I think unfair business practices may not necessarily connote unfair labor practices. They are two different things. And within the context or the bearing of even the statute that we're looking at, it would only be so when you have, thankfully, you sufficiently made that point. Being dominant in a particular sector is not a problem. And that is the way it's always been. It is the abuse. And in saying this, we may perhaps want to cast our minds back to the earliest legislation along this line. I remember that all of this started, if I remember correctly, from what I've read in the United States. As at 1880, Rockefeller Standard Oil was basically holding about 90% of the American refinery. There was nothing wrong with that. But it would appear as if it was left on check. It was able to muzzle out less financially buoyant competitors, creating entry barriers, reducing quality in the market. And that eventually led to the Sherman Act, Antitrust Act of 1890. And I think that is the beginning. Now, at any point in time, if we go back, a little back, even by the time Europe bought into it, the philosophy there's always been, I mean, the philosophy behind competition law is to provide a situation where the law creates a yardstick of acceptable trade practices that will be mutually beneficial to both the producers and the consumer. So it looks at it from the perspective of producers, consumer, and all that. And the letters are well made out. And I think also when we look at Section 1D of the Enabling Act, the Establishment Act of the FCPC, prohibiting restrictive or unfair business practice which prevents, restrict, or distort competition or constitute an abuse of dominant position or market power. Now, we recognize that, and I say this, now before I say this, I think it's important we must recognize that we must not be quick to condemn success or achievement. And I think that is the whole essence of competition law. There's no in saying that It is not being dominant that is a problem. It is when the abuse comes in, when the abuse sets in. So, for example, I had my very good friend, Mr. Atilola, mentioned that it could lead to erosion. Yes, you ultimately want to maximize profits. There's nothing wrong with it. It is when we're talking about abuse, our abuses within context. I'm still talking about context. Let me quickly bring it to bear within what would appear to be the factual situation that has led to all the discussion. And I lean on the factual position as relayed by Mr. Falano, SAN. If those facts, because I think that it would appear as if there's strong disputation on both sides, it would appear to, Dangote Refinery is saying something different, the companies, NUPEC is saying something else. But if it was to be thinking that that is even the position, I think what has happened, I'm talking about context, is the employer, that is Dangote, abused that dominant power to the extent of interfering with trade unionism. That's number one. Interference with trade unionism is not just forbidden within the letters of our labor laws, the Constitution, the ILO conventions mentioned, 89 and all that. But it would interest that even within the corpus of the ILO decent work agenda, it frowns at anything that would appear to be an interference with unionism at any time. But what is even worrisome in this case is that the union that we're discussing or that we're looking at is NUPEC. NUPEC, from my understanding, is the union that deals with low-cadre, semi-skilled workers within the extractive industries. Now, if we take it from that perspective, their membership is automatic. And I say this because of also what I've heard a lot about voluntarism and all of that. If we take it, eligibility is what qualifies a worker for membership of a trade union, of junior employees. That is, these tanker drivers, they belong to junior employees. The implication of it is that the membership is automatic. There is no legal requirement for a consent form or any formal authorization to become a member of NUPEC. The only requirement is on the converse, which is that, if you were senior staff, you need to buy him. In this case, it's automatic because they're junior workers, except you expressly, as a member, decide to opt out. And that indication must be expressly given. Otherwise, from the case law situation or standpoint in Nigeria, it is automatic. And the voluntarism and the freedom to choose which union to belong to is also limited when unions empowered to operate within a clearly defined jurisdictional scope. And that has always been the thinking of the courts, starting from Osawi and Registrar of Trade Union, whether it's 85 or 86 Supreme Court. And then I don't think the industrial court has departed, even though there would appear to be a growing jurisprudence of, let's encourage trade pluralism within a sector. ILO says if others want to form union, they should be allowed to. So if we bring it to the context of what has happened in the Dangote's issue, it is new tanker drivers, whether they can belong to the union, it's automatic. That is even so. It is what would make it more worrisome if the facts were to be believed. I mean, what's been painted in the public domain. It's what makes it more worrisome that the employer can seek to interfere. And I think that is on all levels of wrong. Prof, before I depart on, there were so many things, beautiful conversation that we've had this afternoon, and I must commend rich discussion thus far. There's a need to continually look at how we can come through the laws to make it respond to many of the issues we're dealing with. So I take the competition standpoint, for example, the FCCPC Act. The FCCPC Act, like you alluded to, there are many provisions dealing with, or that would appear to try to intervene when a dominant power in a particular sector is abusing its power and is invariably getting to the employee or the employee and so to the workers. But it would also interest you to note that in the efforts or the attempt to even look into how you can protect the workers of the world, there are provisions in that same statute that there's a need to look at closely in the light of what is even the settled provision or settled position of the law and the new labor jurisprudence as to how many of these issues are dealt with. And I take a particular example, Section 68. 68 outlaws trade, contracts of trade, any contract that would appear to be one that is a restraint of trade, unless it is within 2 years. I think that should have been tweaked further to say is the reasonability test, because it doesn't have the. So what it means is that the law already says if it's one that says, oh, you sign a bond and you must not leave within 2 years, it is okay within the eyes of the law. So there's a need to look closely into those sections. What's case law? On the understanding of case law is not necessarily the number of years. It is reasonability, and reasonability can be objective and subjective. It is not really time bound. It is usually when it goes, in many of the cases, when it goes beyond 2 years, that the law says, based on the particular facts scenario being looked at, it might appear to be unreasonable. But then reasonability test doesn't have to be tied to that. And a lot has been said, and I was trying to I was seriously writing to also intervene in many of the areas. Just a minute.
Yeah.
Yes. So thank you very much. And in asking or in making reference to the Labour Act, the Labour Act is fairly old. It is not an 1872 Act as it is. But for the intervention of the third alteration and the industrial court, we probably wouldn't have any labor law. We wouldn't probably be having any labor jurisprudence at all. So that will not even come into play at all. So there's a need to actively look at how we can strengthen the law. There's a need to review and amend the laws. Now, that takes me to the Trade Dispute Act. Mr. Falano mentioned that maybe the Registrar of Trade Unions should be looking into it. I think it's slightly different. I think it is more of the provision beautifully alluded to by Mr. Tilola and Mr. Bambola, until the connection will not allow him to have a dominant role in the little time that he had to speak, which is that at the end of the day, is a trade dispute act. The beautiful provision set out in part 2, part 1 and all of that should be followed. But even at that, there's a need to look closely. It's a 1976 act. It's been revised a few times. The 85 revision, if you've checked the cases from the courts, even the 85 revision, there would appear not to be so much unanimity on what is set out to achieve in many areas. So there's a need to continually look at it, turn into this law to see how it can be reviewed. And for example, there's another one. The jury's house, whether picketing, for example, which was mentioned there, is one that requires going through the internal grievance remedial measure set out in the TDA before workers can lawfully picket the company. So there's a need to look at it the way it operates in other jurisdictions and see how we can amend the laws and come through the laws. Well, I mean, if there are other interventions, I'll be able to take it further from it. But like I said, what I was looking at basically was a lot of the points eloquently made today. Thank you very much.
Thank you so much, Mr. Folabi Kuti, SAN. Thank you very much for your intervention. I'm sure you all agree with me that we have really enjoyed a robust discussion around this topic today. Abuse of dominant position and unfair labor practices. I think it is only fair that we should give some of our distinguished audience an opportunity to also make some very brief interventions before we then bring the lead speakers back, you know, to wrap up the discussion for the day. It's already a couple of minutes past 4, so we're only going to be able to take 1 or 2 interventions. I see we also have a couple here in the chat room. Dr. Danesi, you have something in the chat room which you may want to respond to there in the chat room. We also have a couple for Professor Abugu. Please take a look at it so that when you are wrapping up, that's the lead speakers, when you are wrapping up, you can just quickly make short interventions in that area. So please, let's see, do we have anybody who would like to speak? We'll just give you a minute or 2 to make short interventions. Otherwise, we'll just give our speakers the opportunity to have another quick bite at the cherry as we wrap up. Okay, I'm not seeing any hands, but I don't know whether, okay. I don't know whether this is, yes. All right, so we're not seeing any hands here, but I've seen some questions in the chat room. Someone is asking about the position of the law on employees being compelled to sign an NDA, that's a non-disclosure agreement. What is that deemed to be an unfair labor practice? He wants to know. I believe Mr. Kuti may have alluded to this when he talked about contracts that are deemed to be in restraint of trade, which are referred to in the competition, the Federal Competition Act. So perhaps it will depend on the circumstances, but let me leave the speakers to address that in their closing address. Then somebody else wants to know the interference of Dangote firm in issues of trade unionism, automatic membership, and voluntarism, and how best to reconcile this. So whilst Mr. Kuti has argued vehemently that membership is automatic, that people can opt out, but they actually immediately become members of these unions. Immediately they enter into the contract of employment.
For junior workers. For junior workers.
Yes, for junior workers, yes, that is automatic. That's his own position. But that appears to be at variance with Dr. Danesi and Mr. Atilola's position that, yes, that's really, when we talk about freedom, it should be interpreted in a way that gives effect to what really freedom means and what it connotes. Perhaps a concern, however, may be that even when employees seemingly agree not to join, please mute yourselves if you're not, yes, please, audience, please mute yourselves unless you are recognized to speak. Yes, thank you very much. So sometimes when employees agree not to join trade unions, perhaps as a condition precedent to their employment, are they really exercising a freedom when they agree not to join? Or is that freedom actually hollow and fictitious? In which case we are saying, yes, there might be a consent, a seeming consent, but that consent is not really free of voluntary consent. It's consent under some sort of compulsion. I believe that's the closest analogy that we can draw in relation to this. So I believe that one of our speakers would also shed light on this. Let us see if there is any other question there. Let's see. Okay. Okay, yes, there's a question for Professor Abugo here too. And please, the organizers have asked me to inform you that should we be logged out, just use the same link to join back again. That will, just in case before we finish, we are logged out. So another intervention has come from one of our participants who is of the view that the discussions really is not, he doesn't believe the discussions really dwell on the with the issue of competition and labor rights, and that the FCCPA actually permits reasonable contracts in restraint of trade. How then can we reconcile that with the Dangote union issue? Can the alleged contract restricting the joining of unions be regarded as a species of permissible restrictive covenant? In other words, when when Dangote says you cannot join, a trade union, how do we interpret this in the light of the provisions of the Federal Competition Act? These are just a few of the interventions that we have in the chat box. And I think we're just going to let me give the discussants just 1 or 2 minutes each, and then the lead speakers will wrap up. So the discussants, you don't have to, nobody has to take up the opportunity. If you feel you have made your intervention, that's it. And also, if you cannot respond in a maximum of 2 minutes, that you don't need to talk to, but I think it's only fair for us to give you just 2 minutes each. And I think I want to start with Mr. Bamiwola this time because
may I just make an appeal to the moderator? May I just make an appeal? Please. I thought this meeting, this webinar was going to end in 2 hours. So I have fixed another meeting, right? So I need to make my intervention before running away. 2 minutes, 5 minutes at most, please. I'm sorry to disrupt the arrangement you have put on ground.
That's fine.
Mine is always, it's actually essentially by way of information. And I think this is important. Once again, I want to commend the organizers of this program. I like to say, with respect to the fact that many of us here, majority are lawyers, and since we are lawyers, I also would like to challenge the automatic membership of MBA. The moment you become a lawyer, you are meant to become a member of the MBA, including Mr. Atilola, Danesi. We are lawyers. Even when you also become a senior advocate of Nigeria, my colleague, Mr. Kuti, will also be a meow. You become a member of Bosan.
Bosan. We are up to that on Bosan.
Automatically. When it comes to the workers, when it comes to the poor people, we are saying, oh, how can you make it compulsory for workers to belong to Nupen? And the reason behind this is this. Because workers are vulnerable, the law took care that it is better for them to belong to unions automatically, provided some of them can opt out if he doesn't want to belong to a union. What has happened in the case of Nigeria, and this is practical, that workers believe that the union will protect their interests. Therefore, they want to belong to work. They don't opt out. They don't opt out. In the case of ASU, and I think I should do this information, ASU is not the only union in the university. It's not the only academic union today. Last year, in an attempt to break the organizational capacity of ASU and the influence of ASU, the federal government to the Register of Trade Unions to register 2 other unions in the academic sector. And they are the Congress of Nigerian University Academics, ONUA, and National Association of Medical and Data Academics, NAMDA. These two unions are perhaps unknown to some members of this audience, but they have not been able to compete with ASU in terms of protecting the interests of the members of the academic community. I don't want to go into, I mean, you also know we have NASU, we have Union of Registrars and the rest of them in the university. The point is that NASU is past the leading union that insists on meeting the provisions of the amendment of 2005, which is that before ASU goes on strike, and I'm happy members of the academic staff union are here, except those who don't participate. ASU will insist, the leadership will tell the branches, go back and conduct what you might call plebiscite on your congresses and ensure they endorse the strike we're about to embark on. ASU doesn't call a strike of 48 hours or 14 days. No. Just 2 weeks ago, ASU met in Jos, the neck. The neck result, we're going to go on strike on salaries, but please go to our branches. These are the questions to ask them. If they say no, if majority say no, we're certainly not going to embark on strike. That's on ASU. We just say this, and I'm happy that my colleague Falabi Kuti SN made the point that, and I made the point earlier, the strike instigated by Dangote was totally unnecessary. If he had familiarized himself with the state of the law, you cannot say you want to organize unions for drivers who should automatically belong to NUPENG. So our colleagues, it's not about voluntarism. The law is not, freedom is not absolute. Freedom that is meant to protect your interest must also be respected. Now, ASU's or NUPENG is not classified as, it's not one of the unions under Section 11 of trade union that are not allowed to unionize. So the fact that it renders what has been classified as essential service, again, the law doesn't recognize supply of petroleum products as essential service. Even those areas under Section 11 of the Trade Union Act, Central Bank, like the Nigerian Army, armed forces generally, and so on and so forth, where workers cannot belong to union, they are also allowed to have consultative bodies to decide on how to negotiate on their behalf and take care of their interest. On NUPENG and PENGASEN, NUPENG did not compel membership. It doesn't have to compel membership. It is automatic that once you're a junior worker in the oil industry, you are automatic members of NUPENG. PENGASEN is different. In the case of PENGASEN, membership is voluntary. And the government also did this in 2005 in order to weaken us. Let's make membership of senior staff voluntary. And that has been the case. But even then, PENGASEN is as powerful as ever before in the oil industry. Senior staff have not opted out. And let me also say about what causes strike in Nigeria. Majority of the strike by ASU are instigated by the government. The government signs an agreement with ASU. When it comes to implementation, the government gives the impression, some will sign under duress. How? But you have an agreement. If you disagree with the agreement or whatever, there are procedures for setting same aside if it was influenced by fraud or force or whatever. But the federal government simply insists we're not going to comply. And that is what leads to strike by ASU. Current one is on salaries. There is no way anybody can justify that a professor is on 500,000 naira in this day and age, whereas a senator takes home every month 21 million naira, apart from constituency projects that they secure. You also have judges who didn't go on strike. So President Bola Tinubu, contrary to the law, and lawyers don't point this out, the only body empowered to the salaries of judges, like all political officers, that is RAMFA, Revenue Mobilization Allocation and Fiscal Commission. But President Bola Tinubu increased the ages of high court judges to 70, including NIC, also increased their salaries. No judge, no high court judge in Nigeria today earns less than 2 million naira a month. But when it comes to ASU, ASU must go on strike, even to ask that, to plead with the government to pay 1 million naira to professors. You know, can go on and on Osawe and Register of Trade, you know, my colleague have made the point that the law has gone beyond that. They now say they can have more unions in the universities, all an attempt to break ASU. But ASU is waxing stronger. The other area where the government has caused problem, it is that the government does not respect the law. I give you an instance. In the union, NURTW, they had an election. Barua was re-elected in August 2023. And what did the government do? They instigated Oluomo faction to go to court. The Oluomo faction lost in the NIC, they lost in the Court of Appeal, and the Court of Appeal is the last court on trade union matters. What has the government done? A group of thugs invaded the secretariat, killed one person, and the government took advantage of that to charge Barua and his executive for murder. But meanwhile, Oluomo and co occupying the secretariat of that union. So if ASU, if NURTW or NSC decide to call a strike on this matter, which is a case of fighting official impunity, we're then going to accuse the NSC of funny strikes, which is when it is not necessary. So please let me therefore thank the organizers of this program for my invitation, and I also thank my colleagues for their robust contributions. Thank you very much.
Thank you very much, Lanet Silk. Thank you.
Thank you.
Prof, please allow me to answer this question, because my laptop will soon go off.
Please, excuse me.
There's no light here.
Sorry, please.
I still would have looked to do my intervention.
Professor Abugo, please, just a moment, please. Please, just a moment. May I know if there's any of the discussants who feels very strongly that he or she must make an additional point, just for a minute? We are really
yes, Prof. Just 2 minutes.
Yes,
just 2 minutes. Sorry, please. Let us do this in another way. Mr. Bamiwola, please, you have 1 minute because we had network issues. That's why I'm allowing you to just quickly, do a 1 minute intervention to wrap up. Mr. Bamiwola, please.
Thank you very much,
Prof. Mr. Tilola too.
Yes, I am on. Thank you very much. Thank you very much, Prof. I'm on.
Please go ahead. You have 1 minute.
Okay, with due respect to the Longness 6, Mr. Femi Falana and Mr. Fola Bikuyi, I want to disagree. The issue of automatic membership for trade unionism or union members has been outlawed. We shouldn't forget that the Trade Union Act 1973 that was amended in 2005 was made before the 1999 Constitution. When a constitution makes provision, we know it's the ground norm. So the doctrine of old membership, what was prior to the 2005 Act, the law has changed. Although it is any current.
Sorry, sir.
Affirming that of a trade union made available. Thank you very much.
Thank you. Thank you very much. Thank you very much.
I am not making an intervention, but Mr. Bangbola.
Please,
Prof,
excuse me, please. Can we have some order, please?
Okay, ma'am.
Please, Dr. Danesi, 1 minute intervention.
Okay, thank you very much, ma'am. I thank the Learned Silk for advocating for ASU, because I'm a member of ASU. Thank you very much, sir. There was a question in the chat box that asked about
The 1 minute is almost gone. Just go straight
okay,
to the point.
All right,
Don't
ma'am. Yes, a trade union, if the registrar of trade union refuses to register your trade union, you can appeal, actually. You can appeal to the Minister of Labor, or you could, from there, that doesn't work, you can go to the NIC, to appeal against the registration, if you are able to get everything you require together. Thank you, ma'am.
Thank you very much. Thank you very much. Mr. Kuti, 1 minute.
Yes. No, I can assure I won't even use that. Well, I think it's directly to Mr. Bambola. It's interesting that you say that that's been outlawed. Unfortunately, you're in this room like every one of us. You are not a judge. This argument was put forward. You may probably want to read off this case. The same argument you just made that has been outlawed was put forward strongly by one of the parties in Biloxi Industry Limited versus National Union of Food, Beverage, and Tobacco Employees. Decision made 30th March 2017. The argument you made, and it was one of the things that I had in mind when I say that we need to look through the laws to really thumb through and really know what that 2005 amendment that you all talk about, the Constitution now came much later than 1999 Constitution. This argument has been put forward. So it's not correct.
Thank you.
Yes.
Thank you very much, Mr. Kuti SAN. Mr. Atilola, please, 1 minute.
Thank you very much, Prof. My intervention is in response to the comments made by one of the speakers and one discussant, to the effect that the procedure for declaring strike under the Trade Dispute Act is too long, is too cumbersome. I say this with all sense of due respect and responsibility. That cannot be an excuse. If we say the law is cumbersome, that cannot be the reason why we should disobey it. What we should do is to ask for reform. That a law is cumbersome is not an excuse for disobedience. It can never be. That is an invitation to anarchy. That will be an invitation to anarchy. So one of the outcomes of this webinar, I believe, is that we should advocate for a more relaxed procedure. But to say we can't follow it because it's too cumbersome is an invitation to total anarchy. Thank you very much.
Right.
Okay, thank you. Thank you very much. Finally, we'll have Olorogun, Professor Abugu. You would give your final words because you're a lead speaker, 2 minutes, Prof.
Okay, thank you very much. I just have a 3-point response to all that have been said. But let me start with the most topical, which is this issue of opting out, voluntarism. You know, with respect to my learned Sikh brother, Kuti, as to the state of the law, and also with difference to some of the legal authorities, case law on the subject, I still want to hold on and stay with the position of Bimbo. You know, the 2005 Trade Union Amendment Act actually did something radical. Section 16A of that act enthroned voluntarism, membership by choice, and overthrew the existing rules of eligibility. The rule of eligibility was the prevalent rule that once you are a worker in an establishment covered by a union, you're automatically treated as a eligible member of that union until you decide that you don't want to, you opt out. So opting out is the old regime. Section 16A overthrew that and said it must be by choice. You must be a member before check-off dues can be deducted. But I recognize the position of Kuti. In Nest Oil and Nupeng, the NIC took this position, that opting out is the state of the law with respect to junior staff. But I respectfully disagree. But like Kuti said, I'm not the Supreme Court. But as an academic who explores the state of the law, the decision in Nest Oil and Nupeng, the decision between CAC and Octrepre, the decision between May and Baker, May and Baker against Nubife, the decision in TIB against Nubife,
Thank
and
you,
the decision
Prof.
all
Thank you, Prof. You've made your point.
I think they are not in consonance with the provision of Section 16A of the 2005 Act. So that's my position. The second one, moderator, just give me one more minute, please. The second one is on the elongated procedure for declaration of a strike. I had written an article some few years ago where I said that nearly always a strike or lockout in Nigeria is unlawful because the procedure is convoluted and circuitous. And there's no union that follows that procedure that will ever declare a strike. In other words, we have a law that is not in tandem with the morality or practice of trade unionism in Nigeria. And like somebody has said, the proposal should be for law reform. Then final intervention on the issue of dominance. A lot of the questions are focused on the employee rights thing. Now, on the issue of dominance, I will simply, let's say Kuti was, raised this issue as to whether, the FCCPC Act, can be used as a weapon to restore labor rights. But I think I've sufficiently made this point that an employer who is in a dominant position, an enterprise who is in a dominant position, would negatively be in a position, to negatively impact employees' rights. Thank you very much.
Thank you. Thank you very much, Professor Abugu and all the speakers. As we wrap up now, we'll have the representative of both organizations come in. First to speak, Professor Abiola Sonye SAN, Dean Faculty of Law. Dean, I'm your boss today. I hold the stick. So please, 1 minute, maximum 2 minutes. And then we'll have the commissioner at the Federal Competition and Consumer Protection Commission also coming to do a very short vote of thanks. Dean of Law, you have the floor. Professor Sonny, please unmute yourself. Yeah. Hello.
Maybe he has been muted and he can't unmute.
Well, let's have Mr. Odion first then. Mr. Odion, representing the Director General of the Federal Competition and Consumer Protection Commission. Just a short message to appreciate everybody and make your short intervention. Oh, okay. So it then falls to me, since neither of the two okay, sorry, please. Please, the Dean of Law has been muted, and I'm trying to see whether I can unmute him here. I'm so sorry. Professor Abugu, can this be done at your end there at the FCCP to unmute him? He said Bori Misoke is the name showing on the platform. I'm sorry, I'm giving my dean additional time. Sorry, just to come in. Yes.
Oh, okay, can you hear me?
Yeah, we can hear you now.
Okay. Good afternoon, everybody. First, apologies from the EVC CEO, Mr. Tunji Bello, for not being able to do this personally right now. It is due to a prior commitment. That said, on his behalf, I wish to express our profound gratitude at FCCPC to the moderator for your excellent performance in the last 2 hours, as well as the lead speakers, our own Professor Joseph Abugu, SAN, and my big brother and friend, Comrade Femi Falana, SAN, for your thoughts. Well, I followed the conversation from the start to the finish. I must say that I found the conversation very, very stimulating. At FCCPC, I must clarify that we agreed to partner with the Law Department of the UNILAG in hosting this conversation in our shared commitment to keep the Nigerian public informed. As an aside, I wish to also declare that I'm a very proud alumnus, not just a proud alumnus of UNILAG, but also a product of the Law Department. That said, once again, a big thank you to everybody.
Thank you. Thank you so much, Mr. Udion. And yes, thank you very much. Professor Abiola Soni, are you with us now? Dean of Law, on behalf of the Faculty of Law. Hello. Okay. Sorry about that. Hello, Professor Soni. Okay, so I think it remains for me to also thank all our excellent speakers and discussants. They have indeed shed light on this very important topic. They have been able to show us successfully the intersections between competition law, abuse of the dominant position, and unfair labor practices,
Hello,
both
Professor
from the
Yewumi.
perspective of employer and employee relations. Okay, Professor Soni is here. Yes, your very quick intervention.
Vote of thanks.
Yes, it's just to appreciate everybody. Professor Soni, you have the floor. Oh boy.
What's going on now? He's still not able to speak.
Okay, so
I think the FCCPC had the market dominance. and abused it in ensuring that Professor Soni UNILAG could not come in. Thank you so much.
Oh my goodness. Yes. So I thank our lead speakers, Mr. Femi Falana, Senior Advocate of Nigeria, Professor Joseph Abugu, Senior Advocate of Nigeria. Thank you very much for the stimulating discussion and your insights into this very important emerging area of the law in Nigeria. We don't really have a lot of precedents. We don't really have a lot of literature, you know, to go by in this field. So the research is just emerging. It's a novel area, and I want to thank you very much for helping to lay the foundation for what we hope will become a very vibrant area of research and practice in Nigeria. Thank you very much. I also want to appreciate our discussants. Some of them got very short notice, I must say that, but they have done excellently well. So I thank you all. I'm grateful to Mr. Folabi Kuti, SAN. I thank Mr. Bimbo Atilola. I thank Mr. Kendi Durowola, and I am grateful to Dr. Rosemary Danesi. Thank you very much. We know that we can reach you all at any time because you are alumni, and when we call, you don't say no. Thank you for rising to the challenge. We're proud of your interventions, and we thank you. I also want to thank our very distinguished audience. You have been very patient with us. We did not start at the right time because of one or two challenges here and there, but we waited, and you have waited until the end, and you have kept making interventions in the chat room in the course of this webinar. We thank you. We really appreciate you, and we look forward to further discussions on this very important topic. Last but not the least, I want to appreciate the organizers of this webinar. Thank you for quickly taking this up, seeing that a lot is going on in this field right now. There are discussions and all that, and you thought to set up this platform for the appropriate government agency, as well as the leading law faculty in the country, to have their voices heard on this very contemporary and important topic. So I thank you for quickly putting this together and assembling a team of experts to make their interventions. Thank you. We really appreciate you, and we hope the collaboration will continue. So I thank everybody. Thank you all very much. Enjoy the rest of your afternoon. I apologize on behalf of my dean.
Professor Yewumi, let me just jump in now and at least thank you. But before I do that, can you hear me now?
Yes, we can hear you.
Okay. At least somebody must thank you, because you actually came on board with no notice. But as a subject matter expert who is also passionate about this, you have discharged yourself meritoriously, and you have done exceedingly well. Let me appreciate Mr. Tunji Bello, an illustrious alumnus of the incomparable Faculty of Law. This partnership means a lot to us, and then we are going to take it further. If you look at the conversation, very deep and important one, it's difficult to tell whose interest the law is actually serving, who's actually gaining from it. The employer is receiving the end of the stick. The employee is also not better off, and we are not hearing anything from the Ministry of Labor, who should actually be the regulator. So at the end of the day, the law is broken. It's a military law. It has not been substantially reformed since then. So time is right for us to pick it up and do something about it. So this conversation is going to continue, and by the grace of God, we will catalyze it into something that is very concrete and that will serve the needs of this nation and the common man. So thank you very much for responding to our call within a very limited notice. So bye-bye for now from my end.
Thank you, Dean. Thank you. Bye-bye. Bye, everyone. Thank you.
Bye.
Bye. Thank you.
Thank you. Bye-bye.